Good afternoon, everyone. I am CA Ruchi Chawla, moderator of this webinar. We are delighted to welcome you all in the webinar being organized by Committee on Commercial Laws, Economic Advisory and NPO Cooperative of ICI. It is my pleasure to be moderator in webinar on RERA, overview of the Uttar Pradesh Apartment, Promotion of Construction, Ownership and Maintenance Act 2010 on 20th November from 2 p.m. to 4 p.m. being organized by Committee on Commercial Laws, Economic Advisory and NPO Cooperative of ICI. In a short while, we will start this webinar. I would like to apprise you about the Committee on Commercial Laws, Economic Advisory and NPO Cooperative. This committee is focused to encourage chartered accountants to shape strategy and policy that unlock economic, financial, and social value while combining analytical foresight with commercial acumen. One of the core areas of this committee is to serve the multifunctional task of analysis, knowledge dissemination, inputs to regulators on policy formulation to develop and publish technical guidance, background materials, etc., and to create awareness for professional opportunities for chartered accountants in commercial laws, economic advisory, and NPO cooperatives. Our eminent speaker, CA Yogesh Kumar Goyal sir, will talk on RERA overview of the Uttar Pradesh Apartment Promotion of Construction, Ownership and Maintenance Act 2010. In this webinar, and we hope that same shall be useful to the members. Now, I would like to give introduction about this speaker. C. Yogesh Kumar Goyal, BCom LLB FCA. His academic and other qualifications are BCom in year 1997, Chartered Accountant from ICI in January 2001, Bachelor of Law LLB from CCS University Meerut July 2001, Qualified Information System Auditor DISA of ICAI, Post Qualification Certificate course on Valuation of ICAI, Post Qualification Certificate course on Indirect Taxes of ICAI, and Post Qualification Certificate course on Real Estate Law and Regulation from ICAI. His work experiences are he is practicing since 2001 as chartered accountant and area of practice is income tax, GST, RERA Act 2016, Tenancy Act 2021, UP Apartment Act 2010 and auditing. Having experience of registration of projects under RERA, quarterly compliances and litigations on behalf of builder and buyers, also giving consultancy to various builders on RERA Act 2016, Apartment Act 2010, and Tenancy Act 2021. Delivered more than 100 lectures on various topics of RERA 2016 and the Uttar Pradesh Regulation of Urban Premise Tenancy Act 2021, Apartment Act 2010, and in various educational seminars of ICAI and Advocate Bar, and also a faculty of ICAI in certificate course on real estate laws. Now, I would like to hand over the mic to our speaker. Please, sir.
Thank you, ma'am. Thank you for giving me opportunity on this Apartment Act. I am sharing my presentation. I think it is visual to all.
Yes, sir. It is visible.
Okay. The topic of today's webinar is the overview of the Uttar Pradesh Apartment Promotion and Construction Ownership and Maintenance Act 2012. I am talking about this act. This is relevant for only UP, but as per my knowledge, as per I have gone through apartment acts of various states, there are many things are common in all the states. So even you may not practicing in UP, but it will be very relevant for your own state because the laws are similar. Around 80% of laws are similar. When this law was introduced in 2010, the reason was given that to provide for the ownership of an individual apartment in a building. The reason was when we construct a high-rise building and on a suppose on a 2-acre plot and 100 units are constructed, how the land will be divided in between the owners. So this act states that the object of this act is to provide the ownership of an individual apartment in a building, to provide the undivided interest in the common areas and facilities appertaining to such apartment. And third is to make such apartment and interest heritable and transferable, and for matters connected therewith or incidental thereto. Means three things has been said here. Number one, that ownership of individual apartment. Number two, the common areas will be also be transferred to the owners, but the condition is that undivided interest will be transferred. That means that interest cannot be divided, but you will have the ownership of that part. And third is heritable. Heritable means you can gift, will, these through this transaction you can also transfer these properties also. Earlier there was some problems that how can these units can be transferred. So now through this act, these apartments became heritable and transferable. The area of operation is state of Uttar Pradesh, and the governor has honorable governor has given his assent to this law on 18/3/2010, and it was notified or with effective from 21/7/2010. And the applicability, it is applicable on every building having 4 or more apartments. And the apartment can be used for residential purpose. Maybe its uses may be residential, official, or practicing any profession, or for carrying on any occupation, trade of business. Other uses as may be prescribed, but does not applicable on shopping mall and multiplexes. So this law not applicable on shopping malls and multiplexes, having regard to their nature, complexity of nature, because shopping mall are maintained in a single unit, and as same also is multiplexes. And this apartment acts applicable on allottees or apartment owners, association of apartment owners, your apartment owners association, promoters, you may say builders, and the competent authority, development authority, oblique local authority. And this act related to the liability of promoters towards the development authority, liability of promoters towards the allottees oblique apartment owners, liability of promoters towards the formation of apartment owners association, liabilities of allottees towards the development authority, liability of allottees towards the promoters, and formation and maintenance of apartment owners association, and liability of apartments owners association. So means this law is applicable on promoters and allottees and the apartments owners association. One special provision is given under section 31 of this act. These provisions are akin to section 88 and section 89 of the RERA Act. And the first section 13(1) is akin to section 89 of the RERA Act, and section 31(2) is akin to section 88 of the RERA Act. This act says the provision of this act shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force. Means any inconsistent provision. In case of any inconsistent provision, this apartment act will prevail, and in case and the other proviso, 31(2) says that the the provision of this act are in addition to the other acts. Means provisions of other act will prevail. And in first 13.1 it says that the provision of this act will prevail in case of inconsistency with other acts. But here the question arises: number one, what about the central laws? Because this act is a state law. So in case any central law is there, the provision of central law will prevail over this act. Number one. Number two, if any central law or state law is there and does not have any inconsistent provision, then provision of this act and provision of other acts, all these provisions will be applicable on a transaction. Now the definition part, what is the building? Because it says 4 apartments in a building. The building means a building constructed on any land containing 4 or more apartments, or 2 or more building in any area designated as a block, each contained 2 or more apartments, with a total of 4 or more apartments in all such buildings. Means some common area may be there, and common amenities, facilities may be there, which are being used by the apartment owners, and building constructed on land having 4 and more units. But what is excluded? Provided that an independent house constructed in a row with independent entry and exit, whether or not adjoining to other independent houses, shall not constitute a building. Means if independent houses having independent entry exit will not covered under this act. What are the competent authority? Competent authority means competent authority having jurisdiction over the land and notified by the state government, because here the government is state government. And the competent authority for adjudication means vice chairman. This definition has been given under rule 21C. Competent authority means the vice chairman of the development authority in whose development area the building is situated. Now, definition of what are the local authorities? I am not taking this. These are the local authorities, and the vice chairman of these authorities will be the competent authority. Otherwise, the district magistrate will become the competent authority for hearing matters relating to this act. Now, promoters. Who are the promoters, and what are their liabilities? The first, who are the promoters? Section 3W of the Apartment Act says promoter means a person, company, firm, association, or cooperative society, as the case may be, by which or by whom the building has been constructed. Here, very limited definition has been given. It does not say who is the landowner, who is selling. Here, they have said that who has been constructed, by whom the building has been constructed. Means a developer becomes promoter under this Apartment Act. When I saw the definition of a promoter under RERA under section 2ZK, it is a very vast definition there. And as per that definition, even the landowner, the developer, even the person having selling rights, all are covered under the definition of promoters. But here, the person who is constructing the project or building became the promoter. Now, what are the liabilities or duties of the promoter towards the authority, towards the home buyer or allottee or apartment owners association? Section 4. Any promoter who intends to sell an apartment shall make a full and true disclosure in writing of following to an intending purchaser and the competent authority. The provision of section 4 are akin to various provision of RERA Act, and I will try to inform you about the relevant provision of RERA Act which are similar to the provisions of Apartment Act. Any promoter who intends to sell an apartment shall make a full and true disclosure in writing of following to the intending purchaser and the competent authority. Number one, rights and his title to the land and the building in which apartment have been or proposed to be constructed. What type of right he has, whether he is a landowner or joint developer, or uh, they have executed executed one joint development agreement or joint venture agreement. What type of ownership the developer is having in that land. This is to be disclosed to the purchaser and also to the competent authority. And similar provision are given under Section 4 of the RERA Act. While applying for registration under the RERA, you have to disclose what type of right you have in the subject land. Now, next is all encumbrances, if any, on such land or building, or any right, title, interest, and claim of any person in or over such land or building. Means all type of encumbrances. You have to disclose what type of loan you have taken, and also uh, any dispute is going around in this land. All type of claims, interest, title, you have to disclose. And similar provision are also there under Section 4 of the RERA Act. Yes. Not moving. मेरे यहाँ तो चेंज हो रही है. एक मिनट. अब आ रही है? अब चेंज हुई है? चलिए मैं ऐसे ही कर देता हूँ. ऐसे ही कर देता हूँ. शो तो हो रही है ना? ओके. This slide now. The plans and specification approved by or submitted for approval to the local authority of the entire building on which such apartment forms part. The promoter has to disclose that what is the plan of the approved plan of the project. And similar disclosure is also required under Section 4 of the RERA Act. Means Section 4 of the Apartment Act and Section 4 of the RERA Act are going side by side. Details of all common areas and facilities as per the approved layout plan or building plan. Similar provision are there in Section 4 of the RERA Act. The nature of fixture, fitting and amenities which have been or proposed to be provided. This is similar. Section 4 in Section 4 of the RERA Act. Details of design and specification of works to be carried on in the project is also to be disclosed to the home buyer. Standards of material which have been or proposed to be used in the construction of the building. When you execute one builder buyer agreement, it's have one annexure in the last of the agreement, and it tells that what type of material the promoter is going to use in construction of the project or has used in the construction of the project or building. Next is all structural architectural drawings, layout plans, no objection certificate from fire department, external and internal services plan of the plan of electricity, sewage, drainage, and water supply system to be made available to the association. Association means Apartment Owners Association. Why these drawings are to be given to the association? The project is required to be handed over to Apartments Owners Association after its completion, and in case of any emergency or any fault in electricity line, or there are some problems, if there are any problems in drainage, water supply, the problem can be located after seeing the drawings only. So all these documents are required to be handed over to the association by the promoters. Next is all outgoing, including ground rent, municipal and other local taxes, water and electricity charges, revenue assessment, maintenance and other charges, interest on any mortgage or any other encumbrances, if any, in respect of such land, building and apartments, to be disclosed to the development authority and to the allottees. Similar provisions are there in the RERA Act. I think Section 11(4)(g). It's required all the disclosures. Shall specify in writing the date by which the construction of the apartment is to be completed, subject to force majeure clauses and intimation sent to such purchaser. Means you have to disclose on what date the project is going to be completed, and such intimation, such a date should be intimated to the purchaser. Similar provision are there under Section 42 LC of the RERA Act, where the promoter is required to declare the date of completion of the project. Declare the penalty for delay in completion of the building, and also penalty in event of non-payment of installment by the purchaser. And the similar provision are also there in RERA Act, RERA rules, agreement for sale rules. So you can correlate both the declaration simultaneously. Declare the conditions for cancellation and withdrawal of allotment and the extent of compensation either way in the event of violation of any of the conditions. These are similar to RERA Act section given in Section 11(5) and also in this is Section 4 of Apartment Act. And the compensation regarding the compensation, the compensation amount or delayed interest amount are given in the relevant rules of agreement for sale rules. Give the intending purchaser on payment of photocopies charges through copies of the document referred to in this section. What type of your plans, development plans, what are your sanction map, what is the sanction letter, all the things can be demanded by intending purchaser, and the promoter is liable to give copies of those documents on taking photocopy charges. Next is plans, specification and other particulars as sanctioned by the prescribed authority, prescribed sanction authority to be disclosed to intending purchaser. Similar to others already covered points. A written agreement of sale to be entered between the allottee and the promoters and to be registered with the concerned registering authority. Means one agreement for sale or builder buyer agreement is required to be executed between the promoters and the allottee, and that agreement must be registered as per the local laws. And similar provision is there under Section 13 of the RERA Act. Minor alteration or addition can be done as per the requirement of the owner. Suppose if owner wants that one additional almirah or specific tiles or other AC duct or may other things may demand by the owners at the time of booking or at the time of finalization of the apartment, that can be done by the promoters. But in case of minor changes or addition in the project, then the reason may be the architectural reason or structural reason. Then in such a case, the such a recommendation should be given by the authorized architect involved in construction of the project and the engineer. But and the same must be intimated to the owner about the addition or deletion in the project plan. Alteration in plans, specification, and other particulars cannot be done without the previous consent of intending purchaser, project architect, project engineer, and also obtaining the permissions of the prescribed sanctioning authority. If you want to alter the plan in the specification, then the consent of intending purchaser, project architect, project engineer, and prescribed sanctioning authority. And also, if the project is registered under the RERA, then two-third allottee permission from two-third allottees is required to be taken, and also permission from the RERA authority is also required under this law. Alteration should be should be only according to the building bylaws. You cannot relation to
Recording
an
in
apartment
progress.
means a person to whom such apartment has been allotted, sold, or otherwise transferred by the promoter. Allotment allotment should be there, or either he has purchased that apartment or otherwise transferred by the promoter. But the under the RERA Act, the definition of allotee is more vast. Next is apartment owners. Who are the apartment owners? Apartment owners means a person or persons owning an apartment, or the promoter or his nominee in the case of unsold apartments, and the undivided interest in the common areas and facilities apportioned to such apartment in the percentage specified in the deed of apartment, and including the lease of the land on which the building containing such apartment has been constructed, where the lease of such land is for a period of 30 years and more. So apartment owner, who are the apartment? Number one, a person who is owning the apartment, and with the apartment he will have proportionate share or undivided share in the common areas and facilities of the project. Similarly, if the unit is not sold by the promoter till the date of completion, then the unsold inventory, in case of in for the unsold inventory, the promoter will be the apartment owner, or promoter may himself be the apartment owner, or he may appoint, or she may appoint his nominee, her nominee, in the case of unsold apartment. And such apartment in such percentage is specified in deed of apartment. What is deed of apartment? We'll discuss later on under section 12 of the UP Apartment Act. And include the lease of land, lease of the land. What is the lease of land? In Noida, land is given on lease by the lessor. Who is the lessor? Lessor are development authorities. They give land on lease to a leasee, and leasee takes these land on for a long period basis, means more than 30 years, around 90 years, 90, 80, 75 years lease. Then in such a case, if the person taking lease for more than 30 years, he will also become an apartment owner. What are the right of apartment owners? Apartment owner will have exclusive ownership and possession of apartment, so sold or otherwise transferred to him. Apartment owner shall be entitled to such percentage of undivided interest in the common areas and facilities as may be specified in the deed of apartment, and such percentage shall be computed by taking as the basis the area of apartment in relation to the aggregate area of all apartments and building. Means, number one, he will have the ownership of that apartment which has purchased by him, and also the ownership of common areas and facilities proportionate to total carpet area to her to carpet area of his apartment, and he will be the owner of that common area. Undivided interest in each apartment owner in common areas and facilities shall be permanent character. Means it will be attached to the respective apartment and cannot be changed. It and shall not be altered without the written consent of all the apartment owners and approval by the competent authority. Means two-way confirmation are required. First given by the all the apartment owners, and second is approval by the competent authority. Number two, common areas and facilities shall not be separated from the apartment to which it happens, and shall be deemed to be conveyed and encumbered with apartment, even though such interest is not expressly mentioned in the conveyance deed or other instrument. Means common, if there is any common areas and facilities, you cannot separate that facilities. Like if you have a parking area attached with your apartment, when you want to sell your apartment, the parking area will also be sold by you automatically. You cannot say that I will keep parking with myself and I will sell apartment only. because the parking area is also part of common area. So in many cases, so that should also be transferred with the apartment. Next is the common areas and facilities shall not be transferred and remain undivided, and no apartment owner or any other person shall bring any action for partition or division of any part thereof, and any covenant of the contrary shall be void. Means you cannot divide the common area with the apartment owners. It will remain undivided and can only be used. Each apartment owner may use the common areas and facilities in accordance with the purpose for which they are intended, without hindering and or encroaching upon the lawful right of other apartments owner. Further is the necessary work relating to the maintenance, repair or modification or relocation of the common areas and facilities, and the making of any addition or improvements thereto shall be carried out only in accordance with the provision of this act and the bylaws. Matlab, you cannot change any things in common areas and facilities. That can be changed only as per the as per the Apartment Act provisions and bylaws. Next is the association of apartment owners shall have the irrevocable right to be exercised by the board. I would like to share one more thing. As per this provision of Section 5, the ownership transferred to apartment owners. Even the common areas is transferred to apartment owners, and undivided share of common areas is transferred to the apartment owners. But the provisions under the RERA Act are contrary to this section. Under Section 17, it says that the carpet area will be transferred to the apartment owner, and the common areas shall be transferred to the apartment owners association. So there is a deviation between the RERA Act and the Apartment Act. In such a case, the Apartment Act will not be prevailed and RERA Act will prevail. But due to the lack of understanding about the provisions, even today in UP, the provisions of RERA Act are not being followed, and only I think in Odisha these provisions are followed. The association of apartment owners shall be irrevocable right to be exercised by the board or manager to have access each apartment from time to time during the reasonable hours for maintenance, repairs, and replacement of any common area and facility therein, and accessible therefrom for making emergency repairs therein necessary to prevent damage and to the common areas and facilities in any other apartments or apartments. Means the board will be the supreme in board or manager or person manager authorized by the board. Means board of association of apartment owners, and it may authorize its manager to check each and every apartment and can visit reasonable hours for maintenance, repairs, and replacement of any of the common areas and facilities therein and accessible therefore, and for making emergency repairs. So he can visit each and every apartment. Further, apartment owner has to comply strictly with bylaws of and covenants and conditions and restrictions set forth in the deed of apartment. Deed of apartment means your sale deed, and failure to comply with any of them shall be the ground for action to recover sums due for damage and for injunctive relief, or both, by the manager or board on behalf of association of apartment owners, or in proper case by an aggrieved apartment owner. Means uh, if there is a loss due to non-following of the bylaws by any of the apartment owner, then in such a case damage can be recovered from him by the board, or in case of loss to any person, that any aggrieved apartment owner, he can also recover the loss carried due to the mistake of apartment owners. No apartment owner shall do any work which would be prejudicial to the soundness or safety of the proposed property or reduce the value thereof, and impair any easement or hereditament, or shall add any material structure and excavate any additional basement or cellar, or alter the external facade without first obtaining the consent of all of the apartment owners. What is this? You have heard about, you may have heard about one building in Gurgaon where the repair or uh, construction work was going on in a apartment, and due to its repair work, whole of the building structure was shaked, and whole of the building was required to be evacuated by the government because the structure was became weak. So no apartment owner shall do any work which would be prejudicial to the soundness and safety of the property, and reduce the value thereof, and or impair any easement. Easement means right to passage, right of passage. So should not create any hindrance. And hereditament means transferability. So each and every apartment owners is required to follow the rules, regulation, and act of the this apartment act. Now, this act give power to an apartment owner that he can transfer his right either by heritable or transferable immovable property. You should deem this property, this apartment, as a immovable property only, and can be transferred by sale, mortgage, lease, gift, exchange, or any other manner. जैसे कि like other properties are transferred in a day-to-day basis. And the rights, privilege, obligation, liabilities, investigation, legal proceedings, remedies, and penalties, forfeiture, similar to other immovable properties, the same rights has been given through this act under Section 7 of the Apartment Act. If the transfer has done by group housing cooperative society, means if one group housing society has been, if the transfer of apartment has been done by group housing society, so it may take the apartment owners will have to submit stamp duty with the registrar. In addition to that, the transfer fees may be collected by the group housing society or association for transfer of apartment in favor of the new apartment owners in its records. But the transfer fees maximum 2%, and the minimum it may be 1%. And in case of heritability, means the death of the owner, then no such transfer fees can be collected from the apartment owners. Next is ownership of apartment subject to such conditions. What are the conditions? That the payment should be made in full. If you have not made payment in full, but you have taken possession, then you may remain in the possession of the unit, but the ownership will not be transferred unless or until you have make payment full and final. There is a provision under Section 53A of the Transfer of Property Act, where says part performance of the contract, where possession has been handed over, part payment has been given, and under the Income Tax Act, it assumes as transfer. But here it says that if the part payment has been done, no full payment has been done, then you can remain in the possession of the unit, but you cannot be deemed as the owner of the property. Next is no hidden charges in the cost of the apartment. The promoter cannot collect any hidden charges, and at the time of agreement for sale, or when purchase are made final in writing, if you are going to purchase such a flat or unit, the price should be fixed at that time. You cannot demand many items later on. As the practice of the promoters are there, they impose so much charges in the name of possession charges at the time of execution of sale deed or transfer deed. Sublease sublease of apartments, so right of re-entry. I This is a very long section in Apartment Act, but I would like to uh, uh, give you information about in short that if the in the case of the property is a leasehold property, means there is a lessor who has given its property on lease to a leasee, and the lessee constructs some building or apartment on that land. Then if the leasee is going to transfer this apartment to different person, that he has to execute sublease deed, separate sublease deed for each and apartment owner, for each and every for each apartment separately. He cannot give a he cannot retain the sublease deed in his favor, but he has to further sublease that unit to further apartment owners. And all the documents relating to the project must be supplied by the lessor to the leasing. And lease deed, sublease deed means lessor to leasee and leasee to sublease. The condition of lease will be binding on subleases also. Sublease can be done only on the same terms and conditions on which the lessee has taken the lease, or unless and until the lessor has approved the changes in the sublease deed. Inspection and breach. If if the leasee thinks that the subleasee has done some breach of contract, means not following the conditions of the sublease deed, he may visit. He has the right to visit and visit the unit of the apartment owner. If he found that the subleasee misuses the land, misuses the apartment, he may issue notice to the subleasee. And in case of defaulting owner, if defaulting owner thinks that the notice is invalid or irregular, he can appeal against that notice in the district court against the lessee. And if the leasee does not give any subleasee does not give any reply to the lessee, then in such a case, within 60 days, the lessee has the right to vacate the property and take possession of that property. If the subleasee filed the appeal before the district court, then if he wins the case, if the lessee wins the case, then only within 60 days he can take possession of the that unit again, and the undivided interest means common areas. He can also take possession of the common areas. And now the right of eviction. If it is not possible to evacuate or evict the premises from the defaulting apartment, then the right of re-entry includes the right of eject the owner from their apartment. You can eject the such a person from that apartment. And if you are ejecting some person from the premises which she has taken on sublease, then you are required to give compensation. You have to pay compensation to that subleasee, and the determination of such a compensation shall be as per the prescribed scale of compensation. And the subleasee has the right to appeal against the compensation amount in district court within 30 days of such decision of compensation. Fresh allotment means the lessee can do fresh allotment of that unit to other persons, and there is no bar on such reallotment. Now, if the lessee fails to act, because the land has been given by lessor to the lessee and lessee to the subleasee. If the lessee fails to act, then lessor can itself come into the picture and can issue notice to the lessee to take action within 90 days. If the lessee fails to take action, then the lessor can directly issue notices to the subleasee. If the routine work is carrying on by the subleasee in the unit, and then in such a case, it must be not be counted as breach of sublease unless and unless he is doing such work which is provision under the Act, and means 6(2). Next is undertaking to comply with the Act. When you execute one agreement with the promoter, you have to the promoter takes undertaking in most of the cases. Otherwise, at the time of executing uh, agreement for sale, registered deed or transfer deed, one declaration is attached with the registry copy that the allotee will comply all the provisions of Apartment Act. The person acquiring leasing the apartment must execute and register a legal instrument, that is a document, in the form and within the timeline that will be prescribed later by rules. Number second is, in that document they need to undertake promise to comply with all the covenants, condition and restrictions under which the apartment is held by the original apartment owner. In other words, they agree to follow the same rules, bylaws, restrictions that apply to the that apartment. And new owners, leasee, are legally bound by the same obligation that the earlier owner had, especially regarding maintenance, common areas, usage restrictions, etc. Now, encumbrances against the apartment. Earlier, the problem was the ownership. Before this act, how can the ownership be transferred to the apartment owners? Now, the apartment owners has the ownership, so they can encumbrance their share for obtaining loans, etc. The owners of each apartment may create an encumbrance, a charge, mortgage, lien, etc. only on the apartment owns by him, and also on undivided interest in the common areas and facilities. And this encumbrance agreement must be registered with the relevant registrar office. And but even the encumbrance is created, the apartment cannot be divided. Means partition is not possible, or subdivided means you want to divide the parking area separately from the apartment, or you want to divide the apartment itself. That cannot be possible if you have executed one or some encumbrances there on the apartment. Multiple encumbrances, change of multiple apartments. If encumbrances has been taken for more than one apartment, then take you can take an finance on these apartments, and you can pay the amount one by one, and you can release the apartment one by one. There is no need to release the encumbrance multiple apartments in one go. You can release the apartment one by one. But in such a case, if there is an encumbrance is on any apartment, the encumbrances right or charge shall remain in force on that apartment only. Very important section, deed of declaration. What is this deed of declaration? This is the whole kundli of project. Declaration. This declaration is given by the promoter to the development authority that what are the details of projects, details of unit, details of common area, details of independent common areas, details of limited areas, all the details relating to the project, size of the unit, common area attached to the unit. These all the informations are given by the promoter to the development authority. And you can check if you have executed one agreement with the promoter and size of your unit is given X, you have to check your size with the deed of declaration filed with the development authority. Declaration by the promoter. The promoter, that is the builder developer, must submit a declaration to the competent authority or for any building constructed after the commencement of this act. This deed of declaration is applicable from the date of commencement of this act. This declaration must be in a prescribed form within the prescribed time and within a prescribed manner. A very long form has been given under the rules where this deed of declaration is prepared by the promoter. And what are the contents of deed of declaration is the declaration must contain full and true particulars of description of the land, including whether it's freehold or leasehold, description of the building, number of stories, basement, number of apartment, principal construction material. All these declaration disclosure are required in deed of declaration. Details of each apartment, its number, location, approximate area, number of rooms, and number of rooms, and which common area it has access to, plus any other identification data. Description of common areas and facilities, lobbies, corridor, amenities, all has to be disclosed in this deed of declaration. If there are common areas oblique facilities reserved for certain apartments, their description, common areas and facilities means limited area or independent area. All these information are required to be disclosed in this deed of declaration. Details of encumbrances on the property, apartment, and their undivided interest as the date of declaration. Any other particulars as may be prescribed by the rules. And if you want to amend the declaration, you have to first take permission from the respective development authority. After taking permission and mentioning them the circumstances which we are lead to amendment in declaration, deed of declaration must be informed to the development authority. Section 13. Section 13 is very important. It talks about that you cannot transfer the property. First of all, you have to give possession of, first of all, you have to execute a registered conveyance deed in favor of apartment owner. Then only you can give possession. And that's such a uh, execution of a transfer deed can only be done after obtaining completion certificate from the respective development authority. No promoter or apartment owner shall transfer or hand over the possession of any apartment constructed after the commencement of this act without executing an appropriate transfer deed and getting it registered under the provision of Registration Act 1908. And it shall be incumbent for such promoter or apartment owner to enclose a true copy of the declaration made under section 12 to such deed of transfer, means to inform that we have declared such and such area for your unit before the development authority. Next is association of apartment owners. We have read the definition of apartment owners. Now it is association, and association has been defined under the act. Association of apartment owners means all the owners of apartment therein acting as a group in accordance with the bylaws. Means all the owners, no one can be left. All the apartment owners are required to be member of the association of apartments owners. So association of apartment owners, there must be an association of apartment owners for managing the affairs of the apartment, including common areas and facilities. Once the project is completed, the promoter is bound to hand over the project to the apartments owners association, and after that the project is required to be maintained by the apartment owners association. Further, if a building project is divided into blocks or pockets, then there is to be a single association for the entire demarcated area. One single association is required. Responsibility to form the association. It is the responsibility of the promoter to form the association along with apartments owner. What will happen if the promoter is not coming forward? And what will happen if the apartments owner are not coming to form the association? We will discuss later on. The promoter must register the association once a certain number of apartments are handed over to the owners. Either a minimum need to be form an association. Association means society. Society needs minimum seven people or 33% of the apartment, whichever is more, provided that building is complete and completion certificate has been obtained. So registration of apartment owners association will be done only after getting completion certificate, and either the number of members required for the project for the formation of society is there, or 33% of apartment owners, whichever is more, then only the society will be, yeah, apartments owners association will be registered. Membership obligation. Membership obligation, if you are taking possession of a flat and no association of allottees or apartment owners association has been not been formed or registered, then in such a case, within 4 weeks from the date of receiving the intimation about formation of the association of apartment owner association, every apartment owners is to required to become member of such uh, association. It is compulsory. And if the association is already exists and a new purchaser has purchased the apartment, then it has to become member before the deed is executed in his favor. Then only the deed can be executed in his favor. Transfer of management. Once the AOA apartment owners association has been formed, then it shall be deemed that the particular project has been handed over to the association. But until all the apartment and units are being sold by the promoter, then promoter will also become a member of apartment owner association for his share of maintenance cost. Also, any interest-free maintenance security amount collected from IFMS, which called IFMS, amount collected by the promoter should be transferred to the association when handing over of the common areas and facilities be taken by the society. And what are the bylaws of apartment owners association? Bylaws are, the government will form a model bylaws, builder model bylaws for apartment owner association, and the same has been notified by the state government, state UP state government on 16/11/2011. And what are the condition of these bylaws? In the first meeting itself, after the notification of these bylaws, every society, apartment owners association, has to adopt the model bylaws as prescribed by the state government. And you may say that model bylaws is just a memorandum and article of a company, which describes all the things that a company can do and will do. And what are the procedures, what are the directors, what are the who are the shareholders, what are the procedures for taking approvals. These are there also there in the bylaws. Number one, the bylaws must cover several mandatory matters, including but not limited to. Number one, how the association is formed. Election of board or management of the association of allotee. Board composition, including retirement, means one third, as per the current provision, one third members are required to be retired in every annual general meeting. Board composition, including retirement of members, power of the board meeting and minutes. All the things are required to be maintained by the apartment owner association as per the bylaws. And bylaws also says that if in the case of any building or commercial building is used for commercial use, then the rent received from the income received from that commercial unit can be used for reduction of maintenance cost. In many cases, there are so much high FDRs are there with the apartment owners association, and they are using interest of those FDR for funding the maintenance charges on behalf of their apartment owners. Number two, audit of association account. It is mandatory that books of account to be mandated under the Apartment Act. Rules for annual general meeting, special meeting, report, income and expenditure must be defined in the uh, model bylaws. And next is insurance. In case of any casualty, in case of any earthquake, building may get damage, or in case of fire in the building may got damaged. So it is must for the apartment owner association to carry on insurance of the apartment and against the loss or damage by fire or any other hazardous things. And as per the bylaws, this has to be done or by a this has to be done by the board or as per the board approvals or as per the building bylaws. Sorry, model bylaws. In case of property is a mortgagee property, building is property is mortgaged, then in such a case the mortgagee may request the apartment owner or the uh, board to carry on to take insurance of that unit which has been uh, mortgaged by the mortgagee. And the insurance cover must be in the name of board for on behalf of all the apartments owner with their percentage specified in the unit, sorry, in the project. And insurance expenses are a common expenses and to be beared by all the apartment owners. Common profit, common expenses, these are means if the society, if the apartment owners association is earning money, earning profits, so these are the profits of common apartment owners association and can be used uh, for reducing common expenses and or may be distributed among the apartment owners. Similarly, all the expenses are the common expenses and to be paid by the apartment owners, and the profit distribution and charging of expenses must be done for the must be done as per the proportionate interest, undivided interest in the apartment. Next is apartment owner not to be exempt from liability. This is uh, uh, no apartment owner can say that I am not using any common areas. I will not pay any maintenance charges. He cannot say that. No apartment owner can exempt himself from paying his share of the common expenses. Number two, waiving the use or enjoyment of any common area or facilities is not an excuse. You have to pay the maintenance charges. Abandoning his apartment in such a case also you have to pay the maintenance charges. Section 24. The act is binding not only to the apartment owner but also will be binding on tenants which has been kept by the apartment owner, employees of the owner, or also the tenant of the owner, and any other person who uses property by any way on behalf of apartment owner. Now, what are the offenses? Offenses are uh, in case of promoter cannot transfer the common areas or whatever the plan approved by the uh, competent authority or development authority, like park, open space, pathway, circulation areas, common areas. He cannot transfer these properties to any person. These property belong to the apartment owners association and can only be used by them for the purpose specified in the sanction plan. So if a promoter sells this land, this is a violation of transfer of sorry UP Apartment Act, and or if he illegally constructs or in violation of approved plan, builds beyond what was allowed under the plan, then on conviction means the order of the court accept that he is a guilty. That is called conviction. The promoter is punishable with imprisonment at least 3 years and up to 6 years, maximum 6 years and minimum 3 years, and fine maybe 3 lakh to 5 lakh rupees. Explanation: even after punishment, the promoter is still liable to restore the common areas facilities to the status as per the originally approved plan. Means whatever the plan was there, he has to restore. You may remember that Twin Tower was uh, demolished by the uh, Noida Authority after the order of the Supreme Court. In case of Supertech, the same reason was there, where the common areas or facilities of other project was used to build a illegal construction. Magistrate jurisdiction. What is the magistrate jurisdiction? Even if ordinary some sentence are outside the power of lower courts, if the lower court cannot give decision in this matter, then the matter will be referred to metropolitan magistrate or judicial magistrate first class, and he can pass the order, a sentence, in imprisonment, fine, or both as per this section, under the power as per section 29 of the civil CPC. And in case of default has been done by the uh, apartment owner, what will be the default? If it done default of section 5 and 6 or violation of any bylaws made by the association, then if convicted, then the penalty will be not less than 10,000 rupees and may be extended to 50,000 rupees. And if he continues to do violation of the act, then 1,000 per day from the date of continuing contravention of the provisions of act. Now, relating to the apartment act, which are very important. The matter, the management board, Windsor Park Resident Welfare Association, through its VP Viplav Sharma versus the state of UP. Appeal number such and such, and the decision was given by the Honorable Allahabad High Court. The matter came before the Honorable High Court. The matter was that the Apartment Act and Society Act, who will prevail? So the court has interpreted that Apartment Act is in addition to the Society Act, and no provision of Apartment Act or Society Act are inconsistent with each other. So both are supplementing each other. Means both the act will carry on. And he says that the association of apartment owners is a society. Then it has to be registered with Registrar of Societies, sub-registrar, in the manner prescribed under the Societies Act, and all provisions relating to registration of society, including the governing the resolution of dispute of the society, would necessarily implicated apply to the association of apartment owners, even though technically it may not be a society under the Society Act. So what is this? Under the Society Registration Act, Section 20 is there, which prescribe for what purposes a society can be registered. Under the Society Act 1860, the purposes given are charitable objects. Or now, after some time, it has been added the government scheme to implement for society registered for implementation of government scheme is also became the charitable societies. But here the apartment owners association is doing not good doing any charity work. So how can a apartment owners association be registered under the society registration act? When the government of UP has prescribed model bylaws, they have said that the registrar means registrar of societies. When this Windsor Park Residential Welfare Association went before the registrar of firms and societies, he says that there is no provision under the Society Registration Act to register a apartment owners association. Then the matter gone before the Honorable Supreme Court, and Supreme Court has interpreted this law that these are societies as the this is the society apartment owners association is a society, but it having different object. So it must be registered with the society registrar, and the object will remain same as per the model bylaws given by the uh, government of UP. Its nature will be is a different nature, and when there is a dispute between the members itself about the working, about the internal working or management dispute will be there, then the matter will be resolved under the Society Registration Act. And if there is a dispute between the promoter and the apartments owners association, then the matter will be gone under the Apartment Act. Number two, Design Arc. Design Arc, Messrs. Design Arc Infrastructure Private Limited versus and others versus Vice Chairman GDA and others. This is a very good judgment. It's interpreted about the section 12 of deed of declaration, about the completion certificate, about the registration of the project, because the court found that in many cases the promoter himself does not want to take completion certificate, because if the completion certificate is being taken, then they have to execute transfer deed in favor of allotment to apartment owners. Number two, they have to form apartments owners association. Number three, they have to transfer the project to apartments owners association. So they do not want to transfer the project to they want to the apartment owners association. So they do not take completion certificate. They file the application, but do not pursue that application to take completion certificate. So the matter came before the court that how can a apartments owners association be constituted if the promoter is not taking interest in obtaining completion certificate, if the promoter is not taking interest in formation of apartment owners association, if he is not interested in handing over the project to the apartment owners association, so then how can the provisions of apartment act be applicable in such a case? So the court has heard both the parties and given its very important judgment. The court said, we are of the view that the requirement of completion certificate to be obtained from the local authorities under subsection 2 of section 14 before forming the registration of the association of apartment owners does not mean final completion certificate. Means if the partial completion certificate is there, then in such a case apartment owners association can be formed before the taking final completion certificate. As the issuance of the final completion certificate may take long time, and that until then the rights and liabilities and the corresponding duties are not provided to be under suspension, and these duties must not be under suspension till the taking final completion certificate. It may take several years for the promoter or, or a promoter may delay the formalities and in applying for issuance of completion certificate to deny the apartment owners to form an association. This will defeat the object of enacting Section 13, which provides for registration of deed of apartment with true copy of deed declaration made under Section 12 to such deed of transfer. The form of declaration, therefore, to be made within 12 months from the date of approval of the plan or where the building has been constructed or in under construction prior to the commencement of these rules, to be submitted within 90 days from the date of commencement of Rule 3 of the Rule 2011 is sufficient for purpose of forming and registration of association for bringing of enforcement of the right and liabilities of the apartment owners and general liabilities of the promoter under Section 5, 6 and Section 4 respectively of the Apartment Act. Means the deed of declarations time limit has been fixed that in case of old project which was commenced before the enactment of Apartment Act 2010, they have to declare deed of declaration within 3 months from the date of order or apply of Rule 3 of 2011. And in other cases, the deed of declaration must be filed within 12 months from the date of approval of plans. And then the apartments owner association can be formed and the right and liabilities can be protected in such a case. Further, in our view that the enforcement of UP Apartment Act, no builder promoter can resist or delay the formation of association of apartment owners under Section 14 of the Act. If the promoter does not get association registered, I have earlier said that if the promoter is not taking interest, then how can the society can be registered or apartment owners association can be registered? So Honorable Court has directed that the apartment owners can get such association registered after a notice giving reasonable period to the promoter, say a month, and to adopting model bylaws. You have to give a notice to the promoter that please form a apartments owners association within 30 days from the date of notice. And if you are not going to form the apartment owners association, we will form ourselves and we will adopt model bylaws. And if the association is already there, he has not adopted the model bylaws, then he has to adopt the model bylaws when they constitute first time. And registrar of societies cannot refuse to register such type of association, apartment owners association, which are formed by the apartment owners association itself, not by the promoter, not being promoted by the promoters. The promoter, however, has to made a member, and very important things the court says, the promoter has to be made a member as he is jointly responsible with the apartment owners to form an association. Means the promoter must be a member of the association. Even if he does not get the association registered and does not join or his authorized agent and subscribe to be a member of the association, he will deem to be a member. Even he does not sign on the documents, he does not want to become a member, but he will be deemed as a member. He will be deemed to be a member of the association for this purpose of enforcement of the act. And as the promoter being a member of the association, his duties and liabilities under the act to be enforced. Means he should be deemed as a member and he will do all the duties which has been applicable on him as a member of association of allottees. Further, the UP Apartment Act 2010 and the Apartment Rules 2011 provides that a complete code of regulating the rights, duties and liabilities and for resolving the issue and dispute between the promoters and the apartment owners. The Act has overriding effect under Section 31. All over other laws on the subject notwithstanding anything inconsistent therewith contained in any other law for the time being in force. We have already discussed Section 31 in the starting of our presentation. So the court has said that again. Next is Resident Welfare Association versus State of UP, writ C number 42123 of 2015, Allahabad High Court. This is also very important judgment, that the provisions above mentioned read with clause 4 of model bylaws makes the membership automatic upon the executing deed of member apartment. Clause 4 of the model bylaws is extracted. Members of association, all person who has purchased apartment in condominium or executed a deed of apartment shall automatically be a member of the association and will pay entrance fees of 1000 rupees. Each apartment owner shall receive a copy of the bylaws. Here the court said that you need not to to submit a membership form when you executed deed of purchase apartment. uh, you have purchased the apartment, you automatically became the member of that apartment owners association and need not to file any other document. And even before paying any entrance fees, you became the member. So even you have not paid any entrance fees, you are member of that apartment owners association. Thus, it is evident from the provision extracted herein above that membership is not dependent upon payment of membership fees, but is subject to execution of deed of apartment, sale deed, or any other document. Membership fees follows purchase of an apartment. Ki membership fees is a is a will be paid only after the purchase of apartment. Next is and the last judgment is SP Singh Yadav, SP Singh Yadav versus State of UP, writ C number 36208 of 2015, Allahabad High Court. The Society Registration Act 1860 is a central act. Article 254 of the Constitution of India provides that if there is any inconsistency between the law made by the Parliament and the law made by the legislature of the state, the law made by the Parliament shall prevail, and the law made by the legislature of the state shall, to the extent of repugnancy, be void. So, and further, the Act of 2010 is a state act, means Apartment Act is a state act, having received a assent of governor on 18/3/2010. Therefore, in view of the provision of Article 253 of the Constitution of India, the provisions of Society Registration Act will have overriding effect over the Act of 2010. Therefore, in my opinion, the dispute with regard to the continuance of the management or dispute with regard to the election of office bearer of the apartment owners association would be exclusively with the ambit of jurisdiction of the registrar of the prescribed authority notified under the Society Registration Act 1860. Means the dispute between the membership will be the matter of Society Registration Act, and dispute between the promoters and the apartment owners, or dispute regarding maintenance, etc., will be a dispute to be raised before the competent authorities. Uh, Now, I would like to inform you one more thing. They talks here that talks about the Society Registration Act, but even the RERA Act is also a central act, and in case of inconsistent provision, RERA Act will prevail over the Apartment Act. So this is my presentation on the Apartment Act. I have covered almost uh, many provisions. Some provisions has been left, which I think was not much value. But all of you should read. If you are not from UP, you should read your state apartment acts and will found that the similar provisions are there in almost all the apartment act. Thank you very much. I can take questions now. Yeah, we can take questions now. Any person having any questions?
I'll be sharing the I'll be sharing the question link in the chat. So whoever have any question, they can question with this link. Now I would like to express my vote of thanks to the sir who have given us his valuable time and valuable knowledge. So thank you so much, sir, for being there on behalf of CCELA. Thank you so much, sir.
So the moderator is coming.
जी.
Yogesh sir, can I myself dictate the question so you can answer?
Yeah,
I
yeah.
don't think the moderator is joining anytime soon.
Okay, okay. You can take questions.
Yes, yes, sir. So the first question says, which law will prevail in cases of conflict between Uttar Pradesh Apartment Act 2010 and RERA Act 2016?
RERA Act will prevail
Yes, sir. UP Apartment Act 2010 and RERA Act 2016. The first
because
question.
the RERA Act is a central act and the Apartment Act is a state law. So, as per the Article 254 and 253 of the Constitution, the central act will prevail over the state act in case of any inconsistency between them.
Right, sir. And so the remaining questions are regarding the webinar itself. I'll handle that.
Okay, okay.
Okay, sir. Thank you, sir. Thank you so much.
I can leave now.
Yes, sir. Yes, please.
Okay,
Thank you,
thank you.
sir. Thank you, sir. Tech support, you can end the meeting. Sanket bhai, just end the meeting. Okay.